Judgments. Please give your slips. Whether your slips have not been entertained. All this listed might have been rejected.
You given your memo earlier?
Yes, madam.
When?
3 weeks back.
Something must have been done.
Probably your lordships were not convinced with the reason.
Maybe.
What is it?
My lord, it relates to the appointment of junior teachers, wherein your lordship is already dealing with certain matters, but in this case, with the need of special educators, be it in special education, none of them.
Already.
So final disposal.
Fresh admission.
Okay.
So it's a fresh admission matter. I beg your pardon.
Please give your stuff.
Because on earlier occasion also given goods are goods worth 54 lakhs have been lying in the godown for the last 6 months in spite of the sanction order. In
I will
the
say.
case.
It's a fresh admission.
Give your all slips.
I may be pardoned to mention, my lord, item 31, 32, and 41, my lord. From an AG will address, will be supposed to address your lordship, my lord. Due to that Prabhasi Bharatiya, that
Which is that matter?
No, 31 is that batch matter where Mr. Subramaniam is also on the screen. That lifting of materials.
Is
That
there?
was,
Is there?
yes,
Yeah.
yes, yes.
Yes, Mr. Sorvani.
I think audio there is a problem with this.
No, they will do it. Yes. They are mentioning it if he is there. Mr. Subramaniam, can you hear us? He is not able to hear.
Yeah.
Who is there assisting him? Please inform him.
Mr. Venugopal is there.
That was assisting Mr. Subramaniam.
There is one more difficulty.
Is Mr. Venugopal or Mr.
Even if
Gopal?
we take up the matter,
Take confused.
it may not be possible for us to deliver judgment.
That's our misfortune.
So that will be useless exercise.
You may give a date.
So we'll give a date.
Yeah.
Yes.
So Lekha ji, join audio. I can see this side. Your host spotlighted
Yes,
your
yes,
video.
Yes, please, allow him to speak. We can't hear him.
I think there's something it says join audio. The host spotlighted your video or everyone. Join audio if you want to make. Separate, na? On that
Can
side.
you hear us, Mr. Subramaniam? But we can't hear you.
He is muted.
You are muted, it seems.
Have you muted yourself now? Let's see. No. I mean, you're not muted from this side, so maybe some problem with his mic.
I call.
Switch off and switch on, it may work.
Why don't you just text somebody?
Mr. Subramaniam, they are seeking adjournment.
That's it.
And I am of the view, speaking for myself, that even if we hear the matter, it may not be possible for us to deliver judgment. Because, so therefore, we are adjourning the matter to some day in February, first week of February.
Fair enough. The Lordship may indicate for fixing a date of hearing in February first week, whenever it is. And there is one item 41, which is slightly different, my lord, which is that non-speaking order. If your Lordship could take it up this side, I leave it to your Lordship.
No, only seek 2 weeks time to file counter affidavit for it.
All right, I leave it there.
My lord, 32 also be accommodated. For 32.
On the
31, 32, and 41.
on the grounds of non-availability of Mr. Acharya and Advocate General, an adjournment is being sought. To stop. List this matter on
11th or 12th of Jan.
February 11,
Yes, yes.
on 11 to 2012.
Great.
31, 32, and 41.
Yes, sir. 32, have you informed the other side? Is not there.
Yes, I have informed the other side.
Where is he?
Mr. Prakash,
Where is Mr.
Mr.
Naik?
Prasant Kumar Naik.
Where is he?
Madam, I had WhatsApp. He has consented. I have.
Okay.
What's up, consent?
I have WhatsApp.
He has responded to you on WhatsApp. All right.
Yes. Okay. Yes.
Item 4, my lord, I am on item 4. I pay 2 days time to prepare the written notice of submission and the citation.
32 gone. What else? 31, 32.
41.
matter.
41 is my matter.
Okay, so connected matters.
Yes.
Sure.
Judgment reserve.
In those days, so I was thinking if it can be before 70. I leave it to you.
We'll do it. We are doing.
These three criminal appeals have been targeted by Honorable Apex Court to the consideration of the suspension of sentence. The previous order passed by the bench is not functioning because of the retirement of Justice D. Das.
So whether the other honorable judge is available?
Yes, yes, my dear.
Listed.
Sathpathy.
What is the period of incarceration? What is the period of custody?
Custody is 6-7 years. In fact, the bail was granted and it was reversed by the Honorable Apex Court for fresh consideration.
All right.
Pardon to make a mention, my lord. And earlier mentioned it on 2nd of January, my lord. The urgency that no confidence motion against the chairman of the Panchayat Assembly is scheduled to be held on 10th of January, my lord. Mentioned the urgency there.
So this is a writ appeal.
My
Single judge has refused.
pursuant to the order of the single judge, a fresh date has been convened on 10/1/25.
Okay.
Pardon, my lord. Item 4 of today's supplementary list. I pay 2 days time to file written notice of submission and
Let the
I pay 2 days time, pick any date.
matter be called, Mr.
Okay.
For judgment item number 1, W1872 of 2023.
My lords, I'm sorry, I wanted to apologize.
Yes, yes, I will. I know for that, but on that one, I said it was-
This appeal is allowed.
Sorry.
Item number 2, WPC 14221 of 2024.
The petition is dismissed.
Orders. Matters under the heading for orders, item number 13.
In my, I am appearing for the exponent matter. Highly my objection,
What is the delay?
242 days.
What is the point?
The point involves is whether the direction of the learned single judge to regularize the services of the respondents contrary to the law. My lords, yesterday the point which was raised, similar, relying upon the same judgment, this order has also been followed. It's related to regularization. Our main point is that this matter does not deal with that judgment because this is, the appointment was with respect to multi-purpose health workers. And in the other case, it is the data entry operators. And second, our next point was that there was no sanction post and there was no advertisement. So the conditions stipulated under the Uma Devi is not followed.
We can condone the delay, give you some money also.
But merit will be heard later because in view of these judgments also. When have we posted the other cases?
3 weeks.
Was it 90?
27.
27.
Finance item number 14 also similar point.
Mr. Mahapatra is there.
Right.
So we have posted those other regularization matters to a particular date in view of the recent judgments of the Supreme Court. Those have to be considered.
Right.
So they'll be taking, we are condoning the delay, but posting for fresh admission on 27th when similar matters are listed. These has been filed, all right. Subject to payment, 14 is how much? How many days delay?
242 days.
Both,
Both.
the payment of cost of rupees? Okay. Payment of cost of rupees 5,000 to the respondent within a period of 3 weeks. Both. Hello. Kali Jokpur said, sorry. Yeah, do you have a copy of, the writ appeal?
No.
Copy of the writ appeal may be served on learned counsel, on Mr. Mahapatra learned counsel for the respondent by Friday. By Friday. List for fresh admission on 27/1/2025, when similar matters have been posted.
In both cases, I'll highly objection.
All right. Objection filed by Mr. Mahapatra is taken on record.
Item 15.
15 minutes similar to item 13 and 14 Miller. There is delay of 233 days. And the point involved is regularization, and there is no sanction post, no advertisement, nothing. And it is similar to item 13 and 14.
It has been issued.
Um,
Which notice? Return within 4 weeks, list after 6 weeks.
Okay.
Yes.
Okay.
Item 16.
16, my lord. An MR employee, sorry, my lord, here there is a delay of 502 days in approaching your lordship in this rate appeal. Issue involved is, my lord, an MR employee at the time of regularization, he was fitted against he was fitted against fitter grade 4 post because he was not having the qualification of fitter grade 1. That is the subject matter of consideration. The Honorable Single Judge has passed an order passing that reversal.
What is where the order?
Sorry, ma'am. Order, ma'am. The lordship will find
Okay.
at page.
So analogous, they've relied on WPC,
Yes,
OSC.
Yes, ma'am. The lordship will find the improved judgment at page 13. It starts at page 13. But the relevant portion, your lordship will find.
13 or 11A?
Yes, ma'am. 11A. 11A.
13 is the previous order. 13 is the order on which it has
Yes.
been relied on. Basis
Yes,
of
that is in the law. Initially, the respondent was appointed as an NMR. Then grade 1 post.
What happened in that case?
That writ application was allowed in favor of the respondent, saying that since he was appointed as an NMR against a grade 1 post, carrying a higher scale of pay. At the time of regularization, since he was not having the qualification to hold that post, he was regularized against a grade 4 post that was having a lesser scale of pay. So, since no notice was given before reverting him, that is why it was passed. We say that he being one NMR employee, rule 2013 rule doesn't apply. That is our plank of argument.
Once you have done it and then you revert him without hearing him.
Yes, fact is, I cannot dispute.
Only thing paragraph 16. Paragraph 16 of an order on which it has been relied. That the record has been set aside, but it has been sent with the record which was sent with hearing and then abandonment.
The Honorable Single Judge has rendered the judgment relying on certain several judgments of the Honorable Supreme Court, so also judgment of our High Court.
No, but this order dated 24/1/2022, whether this was challenged.
24/1/2022.
On which this order, basing on that, has been passed. So what happened to that?
About that, I'll have to take instruction.
That is very important.
Very well.
That is important.
Important.
That is
That
crucial.
is most relevant. As a matter of fact, I have written a letter to them saying that whether this order which has been passed by the other bank, whether that has been challenged or not, what is the
Exactly.
fate of that case?
That is
About
what we
I
are
have-
asking.
Yes. I have not received an answer. Equal option.
Like when filing this writ application, that should have, that instruction should have.
Certainly, I think that.
As requested on behalf of.
Yes, as requested by Mr. Bimbisar Das, learned additional government advocate, list this case on 21/1/2025 to enable him to obtain instructions whether the order passed in WPC OAC number 2917 of 2000, order dated 21/4/2022, passed in WPC bracket OAC number 2917 of 2009, has been challenged by the government. Yes.
Item note 17.
About 17, 18, 19, 23, 24, and 25. All pertaining to that Sarat Chandra Parida case, which has been posted to 20th of January.
Which?
Delay, in some cases, certified copy you have not given.
That you can do it in between.
In
17, 18,
17, 18, 19,
yes.
23, 24, 25.
All have this dispensing within the meanwhile, yes.
That must have been challenged.
Sorry? Exactly, that is what I was saying. Could have been, but you never know. Either could have been.
Yes.
So 17, 18, 19.
23, 24, and 25.
On prayer of Mr. Bimbisar Das, learned additional government advocate, who submits that similar matters have been adjourned to 20, are posted on 20 January 2025. List the case on 21/2025. In the meanwhile, the certified copy of the impugn order shall be filed.
Hmm.
17, 18, 19, then 23, 24, 25.
My lord.
Similar order in all the matters, all 6 matters. Yes.
Item number 20.
That's item number 20 and 21. Similar issues with respect to the reliance upon Nityanand Vishal case, where the matter pertains to pension of job
Contract employees.
Here also posted
to
20th January.
20th January. My lords, in both the matter, a certified copy has not been filed. Party time may be granted.
In the meanwhile, you filed. So 2021?
2021.
Only 2021. This is Nityananda.
This one.
Nityananda Vishal was also an order based on another order, if I remember correctly.
Yes.
And probably the earlier orders has not been challenged. That was the tribunal's order.
Yes.
Okay. Same order as this. Okay. As all a single order would be better. Thank you. 22.
22.
This is regarding regulation dear employee. At the state of admission, the matter was disposed of without.
What is the delay?
There is a delay of 40 days.
When will you file the certified copy?
1 week. Sir.
Mr. K.C. Kaur, learned additional government advocate, undertakes to file the certified copy of the impugn order within 1 week. List the case on 21. List the case on 21/1/2025.
Item number 26.
May not file the delay for 40 days.
40 days.
I'm appearing. Private respondent.
6.
40 days. What is the subject matter?
Because of throat irritation, I remained,
Sorry?
the throat irritation, I remained under the
That
control of the doctor.
arrear salary for a certain period has been rejected by the learned single judge. That is unfair.
On the ground he was absent or what?
No,
You think throat infection?
On merit, my lord.
Throat infection, what is this thing? Oh, for the delay. Okay.
Delay of court.
Consider, IA 598 of 2024. I heard Mr. Vijay Kumar Patnaik, learned counsel for the appellant, and Mr. Sivani Shankar Pradhan, learned counsel appearing on behalf of respondent number 2.
My lord.
Respondent number 2, and Mr.
Respondent
Vijay
number-
Das, learned additional government advocate appearing on behalf of the state of Odisha. Considering the period of delay, which is 40 days, and the explanation offered an explanation offered for condoning the delay, we are satisfied that this is a fit case for condoning the delay in filing the writ appeal. Full stop. The delay in filing the writ appeal is condoned and the IA is allowed. IA is accordingly allowed. Full stop. Have you served a copy of the appeal memo? You'll do it
I have not solved.
today or someday later. Do you have a copy?
Yes, I have probably next week.
Next week, you are serving copy or listing or what?
Next, thereafter, immediately.
Should I read the letter? Mr. Vijay Kumar Patnaik, learned counsel appearing on behalf of the appellant, undertake to serve a copy of the appeal memo on Mr. Pradhan, learned counsel appearing on behalf of the respondent by 13/1/2025. This is the case on 21/1/2025. Yes, for fresh admission.
Item 27.
In this matter, the issue is whether the learned judge is right and justified in giving direction to the appellant to pass appropriate orders for observing the petitioner as a driver from the date of his entitlement. In the present case, he was actually appointed as a helper and thereafter regularized also as a helper. But his claiming for the post of driver, and that has been allowed by him.
47.
Sorry, it's for condonation delay. What is the delay?
274 days.
So notice has to be issued. Notice has not been issued.
My notice has not been issued.
So issue notice. But you have a case
That's the only point involved.
because he was regularized as helper.
Yes, my lords, he has been regularized as a helper. However, he is claiming to become a driver and
Retrospectively or
retrospectively.
issue notice 4 weeks, 6 weeks.
Item 28.
28, my lord. The lords may grant me 3 days time to give the certified copy. There has been delay of 345 days.
In this case, here I have entered appearance on behalf of respondent. And if my learned senior served on me the
Yes, I will serve a copy.
delay condonation petition as well as an appeal memo.
Yes, lords, some the point, my lord, demonstrated, lords, demonstrated post has been declared a dying cadre. After somebody dies or retires or thereafter it will not be filled up. The direction given by the honorable single judge is.
If my learned senior.
We are not hearing on merit, just
I
to
would
know what
also
is the
reply
subject
to
matter.
that point.
You will reply also.
Thereafter, they have given so many number of persons.
You have to take into post of.
But thereafter, after declaring dying post.
All right. Mr. G.R. Sethi, waiving
Number of-
notice, Mr. G.R. Sethi, learned counsel has appeared on behalf of the sole respondent.
Aye.
Sole respondent, full stop. Copy of the IA for condonation of delay as well as the appeal memo may be served on, when will you serve? To be the, Mr. Bimbisar Das, learned additional government advocate, undertakes to serve a copy of the IA for condonation of delay as well as the appeal memo on Mr. Sethi by 11,
Yes, yes, madam.
by 10/1/2025. This case for fresh admission on 21/1/2025. Sorry, this is case for orders on 21/1/2025. Objection, if any, to the IA for condonation of delay shall be filed in the meanwhile.
Item 29.
Madam. 1 day delay.
Let me just check. IA for condonation of 7196 of 2024. There's a delay of 1 day in filing the writ appeal. Considering the period of delay and the explanation offered in the IA for the delay, we are satisfied that this is a fit case for condoning the delay, filing the writ appeal in view of the fact that the delay is only 1 day. The delay in filing the writ appeal is accordingly condoned and the IA is allowed. List the case for fresh admission on 13/1/2025.
Item 30.
So item 6, which is 2794. It's a
One of delay, same and both in file leave to file, not condemnation, leave to file appeal. Is this appeal maintainable?
The appeal is maintainable because of first, in item 6, we have attached a certified copy.
No, I'm not talking about the defects or whatever. Asking what order have you challenged? Order passed by the learned single judge in what, CMP or writ petition or what?
So, obviously, we have challenged the writ petition and we have found in the appeal.
And that's all right. Writ application challenging what?
Not just bond to handle properly,
But it's in a borrower.
this is a consolidation matter.
So you want both the matters to be taken up together already. IA for check the filing of certified copy 6579 of 2024. This IA has been filed for dispensing with filing of certified copy of the impugn order. It is stated in the IA and by, what is your name, please?
Ankita Tripathi.
Miss
Tripathi.
Ankita.
Ankita.
Miss Ankita Tripathi, learned counsel appearing on behalf of the appellant, that the certified copy of the impugn order has been filed in WA number 2794 of 2024, which is also listed today. Full stop. Since the certified copy has already been filed in WA 2794 of 2024, which is pending, the IA is allowed filing of certified copy of the impugn order is dispensed with. This appeal shall be heard along with WA number 2794 of 2024. List both the matters for fresh admission on 13/1/2024.
Item 31, the government is taking time. Interim order. Continue.
Item 6 also you take list along item 6 का जैसे list along with the W797 of 2024 and 31/2024. This is the previous matter, not this. She's mentioning something that's different. All right. This I've said in item 6 fresh admission. Yes.
Has taken time, I think 30.
You said you have exchanged WhatsApp messages.
Yes, the internet continue.
That is that will I don't know who was there in the first hour.
Yeah.
Huh? By the way, interim order to continue till the next date. Item 32. Yes. So like on that, the other prayer on behalf of the government. Hello? Interim order to that.
Case admission item number 3.
Just to remind that Lok Adalat award, whether it's a decree or in the Lok Adalat, whether it's civil court or not, against that 226, thereafter writ appeal. My learned friend,
You had relied on certain judgments to
Right.
demonstrate that.
right, and my learned friend raised a preliminary point of maintainability of the writ appeal. That I'm supposed to reply because my learned friend, subject if my learned friend is completed, then I'll reply.
The losses are no doubt in the order side of condition. That
Let us see what is that order. The points.
yes.
Yes,
312.
Yes, madam.
order number 8.
Act legal service authority.
We intend to adjourn it.
In fact, it's a substantial question.
The questions have been framed.
Right, no, having public importance. This will in fact large impact on the.
And therefore, the questions were framed for future also. The first week of February.
Fourth February 2000.
This matter is list this matter on 4th of February.
Great.
Item number 4.
I am on online matter. I am for the respondent 1 to 4. I paid 2-3 days time for preparation of the matter. As the judgment, I have to prepare arrange some certain judgments. I paid 2-3 days time. Monday, while I have no objection, I will complete my things with the written note of submission and the citations. I pray.
Lordship, this matter is for fresh admission, and one thing your Lordship wanted to clarify as to when was.
So you are seeking adjournment.
For next week, Monday.
We shall stay. That can be done. We can adjourn the matter and we shall stay the operation of the Mr. Mohanty, learned counsel, appearing on behalf of the respondents, seeks adjournment, today also. Stop. As requested, press this matter on. So and so, in the meanwhile, the operation of the impugned order passed by the land single judge dated so and so shall remain in abeyance. Yes. Whenever, 4 weeks. 4 weeks.
Item number 5.
I'm taking responding. Actually, the appellant has taken a loan, SEC, Kisan credit card, and there is a default of near about 49,000. And thereafter, some amount around 35 or 36,000 lying in the savings account. The bank has exercised the banker's lien and putting hold. So against that, they have come and they have suppressed that they have not, in their appeal, that they have not taken it. So there is a default. So bank has every right to go for exercising the right and remain whatever balance will be there, they have to pay. This is a very small thing, but single judge has rightly rejected it, saying if any deficiency in service, then you can approach some other forum for fact-finding courts. And since you have already having defaulted the amount of the loan, so you have to pay. So the single judge is very clear in his judgment. So I don't think your lordship's interference is required. Rather, they have to approach the bank and get it settled. That is why bank has put on hold on the amount 35,000. That is the only case.
Some personal difficulty is not able to. So may I pay?
But why don't you resolve it? It's a very small amount.
Millard, but they have not approached. They have directly come to single judge order. And I read Millard. They have said just
no, even if they have not approached,
they have,
you can.
Millard, they may approach and thereafter whatever the amount.
When do you want?
My lord, kindly pass over.
When do you want?
After next week or in.
All right, as requested.
Next week I have some problem. Let it be fixed.
2 weeks. Yes.
Try to resolve if he's able to pay.
We'll try, but they are not approaching. They are just coming and filing the writ petition, which is not maintainable in my view. It is a commercial transaction. So, and they are also that is well to pay the amount.
Item number 7.
Lord, the appellant is a borrower under SME. It's a small entrepreneur. I'm just making you this small. Yes, my lord. He took a loan of 24 lakhs on 29th of June 2013.
This is the case you were mentioning yesterday.
Yes, sir. Today the auction is going on. So I am very much obliged to you to bring it. And what happened, the single bench judge has not considered the point of our challenge. My challenge was decided in the Supreme Court on 1st of August 2000.
Where is the order?
In the SLP number 9494.
11.
That has been overlooked.
All right, let it.
And already we have paid this settlement amount. That my pleading is we have already paid within the guideline of the RBI, within the guideline of the framework of the SME department, but they are not accepting. They are telling that we have to go for another.
Where is the order of the learned single judge?
The order of the single judge is here, sir. He dismissed the case on 2 grounds.
Annexure 12. Wait.
That the RBI is annexure 12. It is page 85. He said that the order of the RBI is outdated. Which spelled is outdated. That means it is not under the coverage. Of course, subsequently many coverages have been covered. That has been overlooked. I have mentioned in this case, sir. He himself also passed an order on 15th of July, taking this framework into consideration. If you want to allow me to give, I can give it right now. His order.
Okay.
Yes, what is wrong in the order? So, well reasoned order.
Subsequently, in the final order, he dismissed it.
Yes, subsequently, the reasons have been assigned.
Huh?
The reasons have been assigned for dismissal of your writ petition.
The reason says that this is an outdated one. This RBI guideline is an outdated one. That is not the fact.
All right.
So there are several extensions thereafter. That has been given in the framework of guidelines issued by MSME department.
Sorry.
And government court said, Supreme Court said that it is binding on the part of the banks.
Where did Supreme Court say?
Yes, it is page number 54, madam. Supreme Court case 9594. Pro needs versus Board of Directors, Canara Bank.
Come to paragraph 11. That is the reasoning. Paragraph 11 of the judgment. Impugn judgment.
This judgment has been overlooked by the singular.
Maybe we can file a review. That judgment was referred to. Whether the judgment was brought to the notice of the learned single judge.
Yes. I have filed in my argument in the shape of an affidavit. It was brought.
You can file
It
a
has
review.
been overlooked.
Where have you taken this point?
I have taken that one, sir.
Where? In which paragraph?
You could have filed a review.
Which paragraph? I could not follow, sir.
In your writ appeal, where have you taken the plea that this judgment had been brought to the notice of the learned single judge but has not been considered or has been overlooked?
The judgment came later on, sir. Later on, at the time of argument, this judgment came. And that was filed in the shape of an affidavit in my written argument.
So have you taken this point?
In your writ appeal.
Then it's a valid ground
Yes,
for
I have taken.
Mr. Counsel, then it's a valid ground for review. No writ appeal. There is no illegality in the order passed by the learned single judge. You are relying on a judgment which was delivered later after the judgment of the learned single judge.
No, sir, it was, I have submitted it. Right?
The judgment was delivered when?
On 1st of
1/8.
August 2022.
By?
1st of August.
By whom?
By Supreme Court.
And where was the order of the learned single judge passed?
It was passed on 19th of 2024.
So when did you file the judgment?
30th of August 2024 during my argument.
30 August. So the matter was heard on 30th August.
No, it was heard on 3rd of November, 3rd of September.
Okay, so you had
The
filed a
judgment
written
delivered
note.
on the 11th.
All right. So you had filed a written note
Yes, sir.
on 38. Matter was heard on 33/9. Okay. Petition is also before, right?
Where is the judgment? Supreme Court judgment?
Written note, you have given another judgment of a division bench of this court along with your written note.
No, sir. No, madam. I have given the judgment in SLP 9494 of Supreme Court of
There is
India.
a written note in form of additional affidavit filed on behalf of the opposite parties. You are looking where you have given. Additional affidavit filed on 30th. Correct. Thereafter. Exactly. What is that? Let us take. No, this is regarding some benefit.
Who is appearing for the other side?
The bank.
Huh?
The bank.
Someone is appearing.
No, one Gurudatta Kara was appearing in the bank, single bench.
All right. Issue notice. Any action taken by the bank in the meanwhile, shall be subject to final result of the sale. When did you file this appeal?
28th of November 2020.
Where is your application, interlocutory application?
507. IU 5079.
I have filed one, the interim order was there in the single bench. I have filed an affidavit, sir, in praying for a stay.
Where is that?
Where is the IA for stay?
No, I have not filed. I have paid for stay. Again, I have filed an affidavit for praying for stay.
No, but where have you stated that the auction is going to be held today or tomorrow?
Today.
He has filed.
Let-
He has filed. an affidavit. Like, where have you stated? You have stated so many things in your affidavit. Where have you stated that the auction is fixed to today? Everything we have to find out for you.
No, after filing of this Adita bill, auction, they have put into auction. I have filed.
Tomorrow is the,
I
tomorrow
have filed
is,
an additional affidavit.
where is that?
That is there in the file.
Flag A is, flag A was filed on 23/12/2024.
Yes? I have filed an additional affidavit.
Page. Second paragraph, 1.
Yes, sir. There, madam, but it is not with me now.
It is there with us.
Okay.
When counsel appearing on behalf of the petitioner states that the single judge has not noticed in the impugned order the Supreme Court's decision dated
1/8/2024.
1/8/2024, passed in civil appeal number passed on SLP C number 37898 of 2024, bracketed MS Pronits
Pronits.
versus the Board of Directors of Canara Bank and others. Though the same was placed for consideration. First off, he has further argued that the bank has This notice was issued on 16/12 that the respondent bank has issued sale notice for sale of the land and building where is the date mentioned?
In second paragraph, fifth line.
First off, the date for auction sale has been fixed. 7/1/2025 is the date fixed for today for the auction sale. Stop. Next, issue notice. Stop. In the meanwhile, though the opposite party respondents shall proceed with the said notice.
Auction.
No, auction, comma, the final decision shall not be taken without the leave of the court. Yes.
Date.
The the petitioner shall be at the applicant shall be at liberty to make an application for impediment of the successful bidder in the
If any,
auction sale.
if any, something.
Successful bidder, if any.
And
The-
My lord, urgent certified copy to be supplied in the course of the day.
Certified copy.
Item number 8.
May I please, madam?
Mr. Singh, it will be a duty to bring this order to the notice of the bank. Yes. This order. Sir?
May I please, madam? This is not a better bills. Well, because this appellate bank has given some cascading arrangement in favor of borrower bills. Because this conditions of sanction letter was violated by the borrower because of non-compliance of terms and conditions, sustained the loss, sustained because there's no submission of cash flow statement, all that
Which item?
took place bills.
Item 8.
Item 8 bills. So bank bills reduced the cascade limit bills. Yes, even though that was accepted by the respondent bills, subsequently that was challenged where the request for extension was made and that was declined and this reduced to a cash limit credit limit arrangement of bill. Yes, that was challenged before the Honorable Single Judge bills. Yes, the Honorable Single Judge, your Lordship will find the order which I have challenged for Lordship is definitely the interlocutory order. But all this have, as your Lordship knows, all traits and trappings of a judgment bills. That's what has happened. Honorable Single Judge, on the date of hearing of the interlocutory application, the counsel for the bank was very much present in the court bills. Just before the matter was taken up, the read copy was served on him. He requested the Honorable Court, please grant some time to go through the brief and take instruction from the bank bills so that I will reply to whatever submissions have been made by the counsel for the borrower bills. Because that was not considered and the Honorable Single Judge was pleased to pass the order directing that the order which was under challenge had been kept in abeyance. Well, the resultant, the other necessary consequences, the initial cash credit limit, which is a banking practice here of Simnos, 14 crores cash credit limit, which was granted earlier, and because of non-compliance by the borrower, it stood reduced to 6 crores. Now it stood revived. He has already enjoyed about 13 crores and not making any transactions. Making
You are
deposit.
challenging an interim order.
Exactly, my lord, because it has your lordship, there is judgments also, my lords are well aware of. It has trappings of final, it has, because the valuable and substantive right when affected, it takes the shape of judgment, my lord. The recent judgment, I will show to also recent judgment.
Maybe.
Just Honorable Justice Gavai is as author of the judgment. With all respect, your lordship.
No, we are not saying that this intra-court appeal is not maintainable.
Minor.
We are saying that we shall not entertain. You can expedite hearing of the hearing of that case can be expedited.
But sir, if the interlocutory order shall be allowed to be given effect to Mirror, or not interfere with this.
No, have you filed any application for vacating the order of stay?
Today is the second day. Today is the second day after the interim order passed, and today is listed before the Honorable Single.
Today matter is before that, before the Honorable Single Judge.
Today filed to the 63 Millard for the
Millard.
vacation of this day.
Millard, in the meantime, they have given the checks. Because the repercussion is
We
Millard.
are not going to, the matter is pending before the learned single judge.
Millard.
Correct. Now, we are now before a lordship, Millard, against the interlocutory order, which has all trappings of finality, Millard.
Yes.
The reason being, Millard, if the interlocutory that order is to be given effect to Millard, because that is already that directive kept in abeyance, what will happen, Millard? The entire 14 crore, that's a public.
Your all the submissions may be accepted today.
My lords.
We don't know.
My lords.
So why did it appeal? You are maybe accepted by the learned single judge today.
Because now the interim order, your lordship
Mr.
knows
Sahu,
that is subsisting.
had the next date been beyond today, something is there. It's listed today, you make the submission before the court.
What will happen, Millard?
What will happen?
May I, Millard, pray one thing, because the nature of the order is such, which I told for lordship, Millard, I was not, even though I was present, the council was present, Millard, conducting council, without Millard giving single opportunity. It could have been urgent for a day, which your lordship usually do, Millard. He could have taken instruction and matter could have been decided. It could have been. Because now, directing the order to be kept in abeyance, it revives the initial direction for 14 crore public money.
This order was passed when?
This order was passed on 23rd 12.
On 30th.
23rd 12. This 23rd 12.
You could have filed an application for vacating the order of stay. Why did you not do that?
Yes, sir.
Because the order was passed ex parte according to you. It is an ex parte interim order.
No, I was present, but court did not.
Presence, your physical presence is immaterial. Notice is required to be issued.
Court to waive the notice because the order itself will not find. Because of my physical presence report, court waived the notice.
So even then, after waiving the writ application, copy of the writ application must have been served upon you after when the matter was taken up or after the matter was
just before the matter was taken up.
Yes,
because
even then
the council was present.
Even then, it's an ex parte order.
During the course of hearing, argument.
Please see Article 226(3). Please see.
Shall tell you. I understand.
Wait for the vacation of this day.
Liberty of your lordship. Plus, even otherwise, as your lordship suggested, without going into nitty-gritty of all the mirrors. Now that Mr. Panigrahi has already entered appearance mirrors on behalf of the respondent mirrors, your lordship grants liberty by a judicial order so that we will move for application of vacation of stay for the.
That goes without saying.
Yes, Milos. That only kindly Milos, sir. That in that term, Milos, it can be disposed of. My friend has already entered agreement.
Yes, sir.
Deeply obliged. That we also.
Anyway, provided until 263, Lord. He said liberty to more.
That is what, yes.
Yes, yes.
In any case, it is
The present writ appeal, inter-court appeal has been filed, putting to challenge an interim order passed by a learned single judge of this court dated 23/12/2024, passed in WPC number 31627 of 2024. Stop. Next, after some argument, and senior counsel for the petitioner appellant seeks liberty to withdraw this writ appeal. Seeks permission to withdraw this writ appeal with a liberty to file an application for vacating the ex parte ex parte can be mentioned.
Yes, yes.
interim order because he was there and not.
No, they will not have. Expertly right by not.
Ex parte interim order was stay. Stop. Ex parte interim order. Stop. This appeal is accordingly dismissed as withdrawn with the liberty as sought for. Now, Mr. So-and-so has entered appearance on behalf of the respondent. So we make it clear that we have not entered into the merits of the case.
Correct. One small prayer, my lords, order may kindly be made ready so that after lunch I will make a mention before the honorable single judge. I am deeply obliged.
That he is there. Mr. Panigraj will tell me.
Panigraj is there.
In the meanwhile, yes.
Letter is listed.
Mention.
Appearance will be obliged.
Item 9.
Here the petitioner files his application for issuance of direction to the opposite parties to give the work order in favor of the petitioner.
What happened?
Here the fact is that on the 2/12/2023, my lord, the government of Odisha, Odia Language Literature and Culture Department has approved an amount of 2,30,05,000 in favor of the execution of the work construction Biju Smruti Sadan building at Baleshwar, my lord. And after that, on 29/10/2023, the opposite party prepared a report for introduction that the estimated amount of rupees 2,30,05,000 to meet the probable cost of work construction of Biju.
So what do you want?
My lord, the work order has not in my favor. I have already deposited.
Yes.
Let's have to seek instructions.
Take instruction.
I have IA is there, my
We
lord.
cannot issue our order.
What is your prayer? Issue for the year 2023-24.
My lord, I have already deposited, my lord. My lord, I have already deposited 1,60,000 as APS and 8,79,000 as IES, my lord. Which is the annexure 5. Already I have deposited. They are not giving me the work order in my favor. Already I have.
You prayed for giving a work order for the year 2023-24. That has gone.
File your affidavit.
Well, that's 4 weeks time. will be done.
Issue notice to accept unless this matter on 6 weeks. So let a counter that will be filed on behalf of the opposing parties and negative.
Item number 10.
The company is the manufacturer and supplier of jugular fish plates which are being used in the railway tracks.
And accordingly, under Annexure 1, letter of acceptance was issued in favor of the petitioner. Lordship kind of glance, Annexure 1, page 15. That is, page 15, tender number such and such, closing date such and such for manufacture and supply of juggle fish plates for use on welded joints for 60 kgs rails conforming to such and such. Thereafter, my lord, purchase order was placed in favor of the petitioner by Annexure to page 20. And in purchase order, there is discrimination in purchase order and the letter of acceptance. So, my lord, after acceptance of purchase order, on 23/3/2024 under Annexure 3, I made a complaint before the opposite party. Lordship page 20, kindly have a glance.
The matter of Arbitration and Conciliation Act.
My lord, arbitration clause is there. The fact remains,
Or title of your writ petition.
my lord.
Arbitration and Conciliation Act.
Yes,
Why is it listed before us?
it was listed before with a single judge. Yes, because the work order is and recovery of notice is there. It was referred to your lords, my lord.
So invoke arbitration clause.
My lord, what happened, my lord, in the case? As per the agreement, I have to supply the juggle fish.
Mr. Counsel, there is an arbitration clause.
Yes, my lord.
Why will you not invoke arbitration?
My lord, I have invoked arbitration clause, but without giving any notice, and they have cancelled my purchase order and issued demand order under Annexure 4.
That we cannot resolve.
Without giving any reply, I have invoked the. I have written letter to the opposite party on 5/10 that if failed to resolve the dispute, I will invoke arbitration clause.
My God.
But my lord,
What have you done, sir?
my lord, what happened, my lord? As per the agreement, I have to supply the juggle plates in 2 slots.
All right. The present writ application has been filed seeking following relief, prayer. First off, in our considered view, the present writ application is thoroughly misconceived. The petitioner ought to have taken steps for invoking arbitration clause in accordance with the provisions of Arbitration and Conciliation Act instead of filing the present writ application. The writ application is accordingly dismissed as misconceived. Yes.
Item 11.
We are for the opposite party.
That is matter. Annexure 3 is the impugned order you also my kindly favors.
Annexure 3.
Annexure 10.
And
Page 51.
yes.
My bid has been cancelled for 2 reasons, Your Lordship.
Yes.
One is that I didn't deposit the APS within time, and the second is that the bid validity of the tender has expired.
Where is that?
At page number 51, Your Lordship.
Page 51. Yes.
With Your Lordship's permission, the conspicuous of the case is that the
You
bid
did not
validity-
deposit
Right.
APS. Then
My lord, the second ground is not valid because I had already extended the bid validity period. And at the conspectus of the case is, there was a tender floated by the.
no, but what is wrong in this? Did not deposit APS within the specified time.
I'm coming to that, my lord.
Earlier approached this court and withdrew it.
My lord,
Withdrew the writ application.
because there was a subsequent. Yeah, my lord. There was a tender floated by the opposite parties, which was to be opened on 4th April, Your Lordship.
Sorry, sir. Sorry. Where is the order?
My lord,
Previous order?
51, Your Lordship.
No, previous order.
Certain developments.
What was the development?
What are the developments?
My lord, Annexure 7 I had challenged in the previous writ petition, Your Lordship. Annexure 7, they had threatened to cancel my bid and they had threatened that they will blacklist me for this reason. After that, I had preferred an appeal and.
The same issue was there instead of depositing APS within the date you have submitted a reply to. Same thing.
Man,
So unnecessary.
man, one of the conspicuous is the bid was, I was the successful bidder. That was a show cause, Your Lordship. Ma'am, I was a successful bidder, Your Lordship, and I was asked to deposit the APS amount, but the terms of APS amount were changed, Your Lordship. What was in the original tender, that was changed, Your Lordship. Original tender was that term deposit would be accepted, which is the most preferred means of depositing the APS, Your Lordship. My Lord. My Lord, may I kindly find at page number 31, Your Lordship. 31, the term deposit receipt was the term APS deposition. But Your Lordship, when they approved my bid, that is at page number 37, Your Lordship, 38 is the relevant page. They removed this term deposit as the means of APS. That left me with only one option, that is depositing a bank guarantee as the APS, Your Lordship. And they gave me 7 days to do it on 27th. And due to the fact that my bank was under audit and bank guarantee takes 4 days time, for that I couldn't do it in time. I got 2 days delay. And then they issued me a show cause, to which I replied that this is the reason for which I got delayed by 2 days only.
The tender clause, say term deposit.
And the tender clause is, original terms is at page number 31, Your Lordship. Below the table, just below the table, first line, in the shape of term deposit, Your Lordship. That was it. That is very easy. That can be issued.
Let us see. Where is it?
31, just below the table, first line, towards the right. This was the original tender. Term. Because I'm operating at the A level contractor, term deposit is the easiest which can be issued in within hours in a day. But when they approved my tender as the successful bidder and asked me to deposit the AP, they didn't have that clause. They just asked for bank guarantee, which is a 4 days time, Your Lordship. And
Demand.
27th, annexure 3, Your Lordship, page 37. And 38 is the terms for APS, which doesn't include term deposit.
Not bank guarantee, they have given you options.
Yes, those are for small contractors. For an A-class contractor, bank guarantee would be the only thing. Because those are, I'm an A-class.
Time, deposit account, Kisan Vikas Patra, bank guarantee.
Bank guarantee is the only that an A-class contractor. Mine.
Sorry, annexure 3, page 37. While accepting it.
They accepted my bid as a successful bidder, but they asked me to deposit bank guarantee, which I'm ready. I did.
No,
But
this letter says everything. It doesn't say only bank guarantee.
my lord, but the other things are not applicable because we do not, A-class contractor doesn't operate with Kishan Vikas Patra and all that. Practically, it is bank guarantee that was left. I was left.
There is a bar, you can't do it.
No, not bar, because those are small deposits. A contractor operating with a crore plus turnover generally do not operate.
Putting crores, bank guarantee is not a problem.
Not a problem, but it takes 4 days time. That is the only thing.
They granted you 7 days.
7 days time. But the problem is, my lord, my bank where I had an account was undergoing audit, for which they couldn't give me. So I had to arrange the bank guarantee by opening a new account in a new branch. In doing that, I got 2 days.
It's up to them.
2 days delayed, my lord.
Maybe.
Then when I approached them, instead of accepting my term APS and all that, they issued me a show cause notice. Why will not? I should explain that this is the reason for which I got 2 days delay. They,
Have you furnished?
yes, my lord.
No, have you furnished it?
Yes, my lord. But they didn't accept it. I furnished that. I submitted that.
Yes.
My lord. They didn't accept that. They said that we will take action against you. At that time, I approached your lordship that they are not doing anything. They are not taking any decision. And while the matter was waiting for your lordship's adjudication, they cancelled my deal. That is when they can. That's why I have preferred this rate petition. Your lordship, for that mistake of 2 days delay,
They have now blocked my portal, for which I am not being able to apply for any tender in future. And they have moved for blacklisting me. And your lordship, they have taken a ground that I have not, the bid validity has not been extended. Whereas the fact is, I extended the bid validity on my own, promising that I will complete the work without any additional cost, which they have acknowledged at Annex 7, your lordship. So that is the prayer, your lordship. For this reason, my livelihood will be spoiled if I am blacklisted.
No, that is, blacklisting is a different.
They have done it.
The action, no order has been passed.
Yes, they have done it.
What?
Later they have done.
You can challenge that.
And that's what
You can challenge blacklisting. Blacklisting and this thing, they are two different things. Blacklisting is for your entire future.
They have blocked my portal. I'm not being able
You can challenge that. In this case, we can't.
2 days delay, they are not condoning, and for that they have done all this.
They have cancelled the tender. It's not that your bid was rejected and they have taken somebody else's. They've cancelled the entire
Because these are online tenders, they have to cancel it and reapply with all those. That's a different issue, but blocking my portal and
blocking my portal, you can challenge.
And they've taken the ground that bid validity has not been extended, which I have extended, your lordship, on my own. They've acknowledged that I have.
Yeah, Can it be considered?
My lord's one submission only, bank guarantee was there in the conditions of the contract. Both term deposit as well as bank guarantee. It was either.
Term he showed us it is not
My
there.
lord's at page number 31 itself.
Not shown it.
Page 31.
Originally, it was there, but later when they approved, they did that was not. That's what I
Either term deposit or bank guarantee. As per the letter, bank guarantee was mentioned.
Page 31.
Yes, my lords.
Where is it?
Below the table, second line, my lords. First line talks about term deposit receipt / bank guarantee in favor of the divisional officer.
Yes. Yes.
I'm saying term deposit is a 1 hour affair. Bank guarantee is a 4 days affair. Well, they approved. They didn't include term deposit, which was that's what I'm saying. Term deposit would have enabled.
Submission you made, it was as if only term deposit was there, and when they issued it, it was only bank guarantee. You didn't tell us that it was both options were there and only one.
It is all there. It is all there. It is term deposit and bank guarantee are there. But while they approved, they didn't have term deposit, which left me with only one.
You may challenge the order of blacklisting if the order has been passed. You can challenge that. What can be?
I kindly ask them to consider, because
what consider?
8 days delay, and they have taken a ground that the bid validity has expired, which I have extended. They have acknowledged. They have acknowledged that I have extended.
All right, dismissed. Yes.
Item 12.
Liberty may be granted to challenge
that. Okay, we don't know. And counsel for the petitioner has stated that the petitioner has been blacklisted.
Blocked. My portal has been blocked and they reported to black.
That is different.
Please be clear.
No,
Next week I made the submission, you passed the order. This
Sorry.
Sorry. What you exactly want, we'll put it on record. Last date you said, we said this, you said that.
Sorry.
Be careful.
Next. Dismissed. Yes.
Item 12.
It was blocked. They have blocked my portal.
That's
Blocking is
They have
different.
blocked my portal and they have moved for blacklisting.
That is different. That is entirely different. Yes.
May I please election? Challenging the letter dated 18/11/2024, to the extent in which a demand amount has been made of the bid, which was made beyond the closing time. Lordship, my prayer in brief is that I am the successful bidder, your lordship. But however, due to technical glitch or the reason best known to the opposite parties, the bidding time got extended, your lordship, beyond the closing time. And the bidding amount exponentially increased. And now a demand has been made as per the bid amount, which was made beyond the closing time. Your lordship, may kindly turn to page 12, your lordship. Annexure 2. Your lordship, this is the schedule for conduct of financial bidding. of e-auction, Your Lordship. And the sand quarry is at serial number 1, Your Lordship, the one that I was bidding. The
Yes.
time of bidding, Your Lordship, is 11 a.m. to 1 p.m., Your Lordship. Your Lordship may kindly turn to page 13. These are the e-auction tender documents, Your Lordship, the terms and conditions. Your Lordship may kindly refer to the clause G. The closing time of e-auction will be automatically extended up to last bid time plus 8 minutes, so that opportunity is given to other bidders for making an improved bid on that mineral block. Thereafter, Your Lordship, I applied in RTI, Your Lordship. Your Lordship may kindly turn to page 19, Your Lordship, which is the response that I got from the RTI. Lordship may see the last bid time is 3:03 p.m. Your Lordship. As per the terms and conditions of the bid, Your Lordship, the bid time could have been extended most till 1:08 p.m. However, the bidding process continued till 3:03 p.m. Your Lordship. What I am praying is, Your Lordship, since the extension is violative of the tender condition, Your Lordship, therefore the amount that was last bidded at the last closing time, Your Lordship, that amount should have been demanded from me instead of demanding the amount which was extended due to the technical glitch, Your Lordship, because the e-auction process continued beyond the closing time, Your Lordship.
Right?
I was the successful bidder, Your Lordship. I became the successful bidder.
You became the successful bidder because of the bid you must have quoted.
Yes, Your Lordship.
So you.
How are you agreed?
Beyond the day. Beyond the time you quoted more or what? I'm not able to.
Beyond the time, people, Your Lordship, participants kept bidding, Your Lordship.
That is why you.
So therefore, you also kept bidding.
Your Lordship.
Then how can what grievance can you have? What grievance? We were under the impression that the bid amount went up because the time was allowed beyond the auction time.
Yes, Your Lordship. That is why it went up, Your Lordship.
No, and therefore you failed. We were under this impression.
You succeeded, now you don't know.
You succeeded.
Your Lordship, my prayer is to the extent of the amount, Your Lordship. Since the amount,
No,
Your Lordship, since it was, Your Lordship, I participated. Since
you should
the
not have
hours-
participated. You should have said
Given it up.
that now the time is over, you cannot do it. Stop it. And then you could have challenged.
Your Lordship, that I have said, Your Lordship. That I have said after I have sent a representation. Your
No,
Lordship.
you participated in the bidding process. How
Without
can-
participating, Your Lordship, there was no chance for the petitioner to.
Then you took a chance. You took a chance
Your
then.
Lordship, I am challenging since there was a software failure, Your Lordship.
All right, seek instructions, file affidavit. List this matter on 4 weeks. Performance. 4 weeks so as to enable ASC to seek instructions and file counter affidavit in the meanwhile. Yes.
Much appreciated.
Let the matter be called out. Let the case be called out.
Other side is there, so I'm.
When the matter is called, won't the other side come?
Yes, ma'am.
Yeah.
Pardon, Your Lordship. I can refer to Your Lordship and file an interim application, Your Lordship. Selection may not be considered.
No. But
Your Lordship, it may be subject to the outcome of this application.
yes.
Item number 33.
Don't tell that.
Your Lordship, currency, Your Lordship's last order, dated 30/11/24.
My lord, lordship's order is fully complied with. In the meantime, I have instruction, my lord. Already.
No, not.
The amount has already been credited to the account of the petitioner, my lord. Like, I have got the evidence.
What?
No, actually, simply आपको intimate करना है. Second, please. Yeah.
Let me see the order. Let us see the order first.
Let's see.
Lost in kindness. What? Order, case 13 minor. There's one thing.
Your lordship may see 30/11/2024 lordship order, last order.
Just a minute.
They have not paid minor. My instruction is they have
Mister,
not.
let me see. Where is the order? Where is the direction?
Direction is para 9 and 10 minor. Case 13. Your lordship's last order is 30/11/24.
Instruction में ताकि तो program check कर कोई नहीं. तो ध्यान में डाल report नहीं दोगी तो.
Yes.
Lordship, again.
My instruction they have not credited.
All right, let me.
Credited amount is credited to the account of the petitioner. Already 4-1. I have instruction 4-1. Just now received the court.
2 days back.
2 days back. And the next page is the amount credited. That
The petitioner in the present contempt application has alleged disobedience of an order of the court dated
4/4/23.
4/4/2023. Asking WTC number so and so.
WA number 1608.
WA number so and so. Paragraph 9 of which reads thus. From AGA appearing on behalf of the opposite parties has drawn our attention to an office order dated 21/12/2024 passed by the Director, Directorate of Higher and Secondary Education, Orissa, whereby sanction was accorded for payment of subsistence allowance in favor of the petitioner for the period of suspension from 10/5/2022 to 12/4/2023 in compliance of the said order of this court dated 4/4/2023. So, counsel appearing on behalf of the petitioner states that the said amount has yet not been credited in the petitioner's
next
account.
page below. Next page.
AGA appearing on behalf of the opposite parties, on the other hand, has submitted that the said amount has been credited in the petitioner's account
Lot of
We are-
pages. Lot of.
No, that table, that account number is mentioned. The
Well,
amount,
that is-
the amount is mentioned. Bank account number is mentioned. Yes, that is.
No, no. Apollo statement record of your statements.
3,68,000 लिखा है कैलकुलेटर
3 lakh custody.
68,000 3 lakh
Actually, after 6 months, I am entitled 75%.
That you can say that different if they have not paid the exact
But
amount.
they have not paid a single. My instruction is that they have not credited. Till date, they have not credited. Date I will take instruction, matter will be taken up any other day. Let my brother friend submission and recorded. They have credited.
So this is the amount.
Yes,
That is bill, that is the bill.
So this is 371. School and mass education, what is this, director? What is- Say 4-1 West.
The petitioner's account as per the instructions which she has received. Let's talk this case on Monday. The first 5 cases, most of land council for the petitioners shall be at liberty to seek instruction.
Monday also move affidavit.
Note 34.
The procedural direction for OPSC had given a copy to me. Yesterday I have got it in the evening. That's my call 1 week after so that present position I can ascertain.
As requested by Justice and senior counsel appearing on behalf of the OPSC. List this matter on 1 week within first 5 cases. Stop in the meanwhile. Can you file your affidavit in the meanwhile? Because it's a clear case. Can you file it?
What I had gone through the bit that in the review, in the writ petition, he was not a party. He was not a party in the review petition. Sorry, writ petition. So now they filed. He just woke up from the slum after so many years and saying all this allegation. He has never agitated his grievance at any forum. After the batch of cases were filed before the learned tribunal. The tribunal directed to review the selection process. Then the candidate who was selected and another was replaced. The candidate who was replaced and he came before the Supreme Court. The Supreme Court directed, since he has already continued for so long, he should be adjusted, and who replaced him also.
But that gave cause of action for the petitioner. That was the cause of action.
It's a cause of action, but
I am filing an affidavit. I have searched from that list. I have got the respondent. There are 5 other persons also securing higher mark than me.
Maybe.
They're filing the affidavit.
Slumber.
So they will now wake up now.
They're still in
Your
slumber.
lordship's
Then shall I file it here?
Fencitors, my lordship, matter should be set at rest.
One is fence sitters, one suddenly you realize somebody has got who was not even a fence sitter has got. So then the cause of action comes
Yes, they
alive.
got
In that respect,
Shall I
lordship,
file it here, my
right?
lord?
See, they did not have any cause of action till a direction was issued for your continuance.
His continuance is known to him from 2017, 16. That is known to him.
Consider that, you're not passing the final.
Shall I file it in the registry, my lord?
File it in the registry.
Your Lordship, if I may just clarify to that regard, Your Lordship. Your Lordship, what my learned seniors are implying is that the appellant should have been a litigation monger. Your Lordship, that was not the case. The cause of action only arose when I was called for a selection, Your Lordship. I was never even called for a selection because this private opposite party was sitting there by purporting himself to be a sportsperson, and that's why he was called. And I, in spite of being ST, was not called. Then when this whole the investigation started, Your Lordship, thereafter more 10 people were called for a selection process. Thereafter I qualified. Then I approached my case. I went to the tribunal, challenged it.
All right.
I was
2 weeks.
2 weeks after, very old matter.
Your Lordship,
No.
File your affidavit.
We are going to file an exhaustive counter affidavit. We have prepared it. We will file within 2 days.
2 days,
We
Your
have
Lordship.
prepared.
Your Lordship may take up the
Then
matter
1
this
week,
week.
let it come after
The
1
gamut
week.
of the case.
Because Your Lordship has heard this matter at length.
No, that is a material. Right?
Yeah,
I've got so many matters. I am yet to deliver judgments in so many cases.
Because Your Lordship has, Your Lordship may take it up next week.
1 week.
Would it be 2 weeks after?
We will give you further time.
File it, file it.
We will give you further time. We are not at all in a hurry because The state has prepared some affidavit. Let us see what stand the state has taken. Can give.
Your lordship fix a date. Your lordship.
15th.
That is 1 week. It can't be before that.
Item number 35.
Milord, item 35, I am Naveen Kumar appearing through VC, Milord.
Yes.
Milord, in this, my lord has issued notice and state government has filed counter, Milord. Despite notice, the others have not filed counter.
You file a rejoinder.
We have filed a rejoinder also, Milord, and on my part, this pleading is complete. I am ready with the matter, Milord. The sought issue is, may I proceed, Milord?
There for the opposite party. Counsel has appeared.
Who is for the other?
Nobody has appeared. You are often find this is a notice in this. Neither postality nor unserved admission notice is to office pattern 5 weekend.
Yes, but there is some name. By mistake.
Mr. Biswajit Das had, I think, appeared, Milord, for the OP number 4,
He
3
has
and
appeared in the writ petition or he has appeared?
in this review petition, Milord.
The writ petition has appeared.
Name
You are appealing for whom?
Yes, petitioner.
Oh, you are for the petitioner.
We
We can take up the matter tomorrow. Can you inform the Land Council who appears? The other side.
We'll do that, sir. I know Biswajit Das, I'll call him.
Representation on behalf of. The respondent or opposite party? What do you call?
Opposite party, Milord. Opposite party,
Opposite
4
party
and
number?
5. 4 and 5.
4 and 5. So stop. We'll discuss this matter tomorrow.
So he has appeared only for OP4.
Yeah.
So counsel has appeared already.
Dole and Council has entered appearance on behalf of opposite party. 4.
Your lordship is calling it tomorrow.
Tomorrow.
Deeply, Milord.
36.
This is the NOC on matter. He just now given me a rejoinder. Let it come next week, I will give the reply. Just now he has given me rejoinder.
One counsel representing the DMLT states that a copy of a rejoinder to the counter affidavit has been served by learned counsel for the petitioner today itself. So he seeks adjournment to consider this counter affidavit, said rejoinder. So this case 2 weeks. Yes.
Item 37.
Legal matter. I had last time taken time, they are getting government proposal to develop 4 weeks time later because all the stakeholders have to be get together and to take decision. The PWD, ASI and JD department. These are all recorded orders. So I want 4 weeks time. So where the development project is concerned, that is examining, AG is discussing with the officials and all that.
No, but we have said that an affidavit be filed.
Collector's
regarding the
affidavit.
steps to be taken for removal of unauthorized.
For removal already
Definite plan-
action has been initiated by
definite
now.
plan that you had wanted 4 weeks time, that you want time. What about the affidavit regarding encroachment removal?
Removal regarding notice has been given by actual survey under 15 days time is over now.
Affidavit.
Now steps are taken for the removal. But what the temple that is existing, Baraguja temple, that is to be remain and other encroachment by outsiders that is to go man. So AG is examining the matter with the government culture department and all that. So we want 4 weeks time to come with that plan for development and encroachment in the meantime.
Plan development is different. That
Yes.
will take time. But what about the removal of encroachment? What
Already
you have done?
initiated.
So what you have done, file an affidavit.
Actually, collector's affidavit, I have got the instruction, I will file the meantime. But central government has taken already step, architecture survey has already issued notice on section 19 of the act for removal. And DAG has information of it.
We have served the notice, we have taken steps. And there is a 2 part, one is the archaeology survey and the monument persons. So both are being under the examination and found that
It is admittedly some encroachment is there. So that should be removed after complete the process of. That should give some time thereafter. The hard that this Jain temple is also constructing unauthorized. They are also constructing. Everybody is constructing on their own way and pushing the land. Like this, they are going. SI is planning to give notice to all this. Like, already processing started by issue some notice.
My submission before the lordship, let it be taken up next week, so that in the meantime, they should file the affidavit in compliance with the order passed by this honorable court.
That affidavit is filed by Architecture of India because notice for eviction has already been given. 15 days time is already over.
Already been filed by us.
Right.
No, pursuant to the order dated 3/12/2000.
On 3, my lord, on 3/1/25, collector has already moved the GA department also for the taking steps for eviction. That has come, will file the affidavit in a minute.
So when will he file affidavit? Let him file the affidavit tomorrow.
Day after tomorrow will file.
Day after tomorrow.
Instruction has already come to file.
And what about this definite plan?
Plan, I have taken the 4 weeks time more because they are examining it will take some time. PW, EAD, they are all stakeholders have to sit together and take decision now.
No, but then you had made an incorrect statement on the last date on 3/12/2024. Because we recorded your statement that it will take 4 weeks time for a state to come out with different plan. Now you are saying 4 weeks.
Lord and AG is coordinating with the departments and all that. Today morning, London AG said me that I am taking you take 4 weeks time so that in that time, meantime, that will matter.
Mr. Kar, London government advocate, appearing on behalf of the state of Odisha, has submitted that it will take further 4 weeks time for the state to prepare a definite plan for development of Khandagiri caves in the district of Khurda. Stop. When the matter was earlier taken up on 3/12/2024, the court was informed that within 4 weeks, a definite plan for development of said area shall be prepared. Stop. Mr. Kar has submitted that the London Advocate General, Odisha, is coordinating with officials of various concerned departments of the state government for chalking out a definite plan for development of Khandagiri caves. Stop. Next. Learned DGSI, appearing on behalf of DSGI, appearing on behalf of the Archaeological Survey of India, has submitted that steps have been taken for removal of unauthorized encroachments from the area. So stop. The district magistrate has filed affidavit.
Hello? Day after tomorrow will file it, but district magistrate are ready to GA department for taking step for
All
eviction.
right, file whatever. File it, we will take up the matter again on Thursday. List this matter on Thursday. Stop. In the meanwhile, an affidavit must be filed on behalf of the district magistrate Khurda in the light of this court's earlier order dated 3/12/2024. File it. You will also file affidavit.
No, we are asking the parties, the steps you have taken.
Already we have filed, my lord. If subsequent development is there, we can file.
After 3/12 you have filed?
Yes. After 3 necessary.
You don't file.
No.
Let us see
After
what it
3/12
is.
we will not file.
No.
Yes.
We will file on 11 AM 2024. There are.
Item number 38.
In item number 38, on behalf of Debashish Naik, who is appearing for respondent, 2 weeks' time may be granted for filing counter affidavit.
As requested on behalf of the opposite parties.
Food Corporation of India.
Bracketed Food Corporation of India. This matter on how much time?
2 weeks' time may be granted.
2 weeks for filing a counter affidavit. Yes.
Item 39.
Sorry. For a minute. Tomorrow. As requested. Tomorrow.
Item 40.
That filed my rejoinder today. But the rejoinder could not have come on record. I filed it today in the morning.
Have you served?
Yes.
Let's have a copy of the rejoinder.
It is stated by. Let you serve a copy. Counsel appearing on behalf of the petitioner that a rejoinder affidavit has been filed in the registry today itself. Of the said rejoinder affidavit is not there on record. So a copy of the said said rejoinder of the rejoinder has been served upon learned counsel for the. Yeah. Number 1.
As the union minutes, we have served at the counter because
You got it.
Let a copy of the rejoinder be served upon the council representing the Union of India. Stop. List this matter on 2 weeks.
Item 41.
Other cases we have granted stay, this we have helped the inspection. What are the best
Fast.
My lord, in this case, I am filing to the counter. This is regarding revocation of NOC.
I received the counter in course of the day.
I have given a copy also to the government. I have
Kindly take up this matter on Monday, Your Lordship, as the last date is on 15th.
Council appearing on behalf of the petitioner states that copy of the counter affidavit filed on behalf of DMET has been served upon him today itself.
Your Lordship.
Stop. He seeks adjournment to consider the said counter affidavit.
Monday, Your Lordship.
Stop. Does this matter on 15th?
15th.
15th is better.
15 is the last day, Your Lordship.
13th.
My lord, I am filing the counter in the history.
One line is that's
That the counter affidavit be filed in the counter affidavit be filed by on behalf of DMET in the registry. First of further, let copy of the said counter affidavit be placed on record on the next date.
The information below the 35. I just missed with the register. By the time I reached below the matter was
35.
35 below. So it is now being directed to be perhaps is listed tomorrow. My junior told me.
Yes.
My humble request, below. Last date I was present before my lord. I am the opposite party number 4, and my presence is recorded. And here, my lords, this is a review matter actually. It is between the government and not, but because the entire area is occupied by me from 2016.
Tomorrow.
Tomorrow.
There.
My lords, I will not be there, my lords. Number 1. Number 2, also tomorrow, perhaps that timing will be clashing. I have some matters. I humble request.
Associate or somebody
Yes.
can ask for whatever.
Otherwise, and in the meantime, my lord, since I'm the opposite party number 4, I'm the person who is directly, if at all, your lordship pleases to allow that petition. So therefore, my lord may permit me to at least tomorrow my junior will appear, and if at all, any manner your lordship will permit us to file the counter affidavit. Because that is not recorded, so we didn't
tomorrow,
file.
Mr. We don't know. Tomorrow, if any request is made, we will consider.
Yes. So,
Why did you file the counter affidavit?
Yes,
They
yes.
can ask your junior to mention that it has been filed. Simple as that. Why do you have to pass another order for filing counter affidavit?
All right, because the registry would not accept it. That's why, because there's no direction. So I only to that extent I thought of.
Our registry is very polite.
Then,